Hey everyone, good to see you. There's been a lot happening lately, and it's the kind of movement that can change what everyday life looks like in California if you care about how courts interpret the Second Amendment. Earlier this summer, the Ninth Circuit struck down California's so-called 1 in 30 rule in Nguyen v. Bonta, the law that stopped most people from buying more than one firearm in any 30-day period. That was less than 2 months ago, and the state hasn't asked for a rehearing. For now, that decision stands as part of the circuit's precedent and is already influencing how similar cases are viewed. That was a solid, clear win, and it raised hopes we might see a consistent approach in the Ninth Circuit on these kinds of restrictions. The court applied the post-Bruen framework, looking to text and history, and found no tradition supporting a purchase cap like that. It showed a willingness to treat acquisition limits as more than just minor inconveniences. But almost immediately, another major case needed attention: Rhode v. Bonta. This one challenges California's ammunition background check system, something residents have been living with since mid-2019. Under it, you can't get ammunition shipped to your door. Every purchase, whether in-store or picked up from an online order, goes through a licensed vendor. At the counter, the clerk runs a background check for that specific sale. If your information doesn't match what the state's database expects, the system denies the transaction. You go home without the ammo, even if you've done nothing wrong. The roots go back to Proposition 63, passed by voters in 2016. It rewired the way ammo sales happen: vendor involvement, point-of-sale checks, and per-transaction fees. These requirements took effect on July 1st, 2019, and have been in place ever since. This year, the per-purchase fee even increased, adding to the cost over time. Supporters say it keeps ammunition from prohibited persons. Opponents say it mostly snags law-abiding buyers and creates red tape. On July 24th, 2025, just a couple of weeks ago, a three-judge panel of the Ninth Circuit issued its decision in Rhode. In a 2-1 vote, the court held that the background check system violates the Second Amendment. The majority said the state failed to point to any comparable historical tradition of screening each individual ammo sale, while the dissent saw the burden as minor and justified. Whatever side you're on, the ruling lined up with Nguyen in treating modern purchase process barriers as constitutionally suspect without strong historical support. Then, just last week on August 7, 2025, the state filed a petition asking the court to rehear Rhode, either by the same panel or en banc. In the Ninth Circuit, en banc means 11 judges, including the chief judge. Take another look. While the court decides whether to grant that request, the panel's ruling is on hold. As of now, nothing has changed at the counter. Ammo buyers still go through vendors, still have each purchase checked, still pay the fee. The legal hold keeps the current system in place until the judges make their next move. Since the Supreme Court's 2022 Bruen decision, courts have been applying that two-step approach. First, see if the Second Amendment's text covers the conduct. If it does, the government must show a matching historical tradition to justify the modern law. That's the lens both Nguyen and Rhode were viewed through, and it's shaping how acquisition restrictions are treated in this circuit. What happens next in Rhode will test how far that reasoning goes. So, here's where we are right now. Mid-August 2025. The panel ruling in Rhode v. Bonta is out there, but it's sitting under a legal hold because of the state's petition filed last week. That one filing changes the pace of everything, until the Ninth Circuit decides whether to take the case en banc. There's no mandate, no order telling the state to stand down, and no shift in the way ammo is sold. It's a reminder that in appellate litigation, even a big win can pause in place while procedure plays out. Let's talk a bit more about what en banc means in this circuit and why it matters so much here. The Ninth Circuit is the largest in the federal system, covering 9 western states and 2 Pacific territories. Because it has so many active judges, nearly 30, it uses a limited en banc panel of 11 judges instead of all active judges. That group always includes the chief judge, and the other 10 are selected at random from the active roster. In theory, en banc rehearing is reserved for situations where there's a need to secure or maintain uniformity of the court's decisions, or the case involves a question of exceptional importance. In practice, especially on hot-button constitutional issues, the state will almost always file for it if they lose. Historically, in Second Amendment cases at the Ninth Circuit, going en banc has not been friendly to challengers of state gun laws. There are notable examples: magazine capacity bans, carry licensing frameworks, where a panel struck down a law, The court went en banc, and the larger panel reversed. That's why the request here has a lot of people in the 2A community bracing for a possible reversal. It's not inevitable. The court can also deny the petition, in which case the panel ruling stands. But looking back over the last decade, the odds tend to run in the state's favor once a case goes en banc. The timeline from here isn't lightning fast. The plaintiffs have a window to respond to the petition, 21 days from when the court ordered it, which was August 8th. That means their brief is due by August 29th. After that, the judges will circulate and vote on whether to grant rehearing. Sometimes that decision comes within weeks, other times it takes months, depending on how many other cases are also pending en banc petitions and how much internal debate there is. So, while it's possible we could see movement in early fall, it wouldn't be surprising if this stretches deeper into the year. What does all of this mean for you if you're in California and you buy ammunition? As of today, nothing changes. You're still looking at the same requirements that have been in place since July 2019. You go to a vendor, you present your identification, the system checks you against the state database, and you either get an instant approved or you get denied and have to troubleshoot the mismatch. Online purchases still have to be shipped to a vendor, where you pick them up in person after the check. The fee per purchase is still in place, and as noted earlier, it increased earlier this year. So the experience at the counter or with your local shop isn't any different today than it was before the panel decision came down. For vendors, especially smaller shops, the uncertainty is real. They've been following the case because a change in the law could mean more straightforward transactions and less paperwork, which in turn could speed up sales and reduce friction with customers. For now, they have to keep doing exactly what the regulations require, because acting otherwise while the legal hold is in place would risk their licenses. That's part of why you haven't seen any sudden shift in how stores are handling ammo sales since the panel ruling. No one wants to be the test case for enforcement. Zooming out, Rhode v. Bonta is one of several major Second Amendment cases making their way through the Ninth Circuit in the post-Bruen era. The Supreme Court's 2022 decision in Bruen set the framework. If the text of the Second Amendment covers the conduct at issue, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. Interest balancing, the old means-ends tests, are off the table. That shift has been reshaping litigation from carry permits to magazine limits to purchase restrictions like we see in Nguyen and Rhode. The California laws at issue in both cases are relatively new inventions, and that lack of historical analog is exactly what's driving these panel outcomes. It's also worth remembering that Rhode isn't the first time the ammo background check regime has been in court. Back in 2020, a district court issued an injunction blocking it, calling the system overly burdensome and prone to false positives. But that order was stayed on appeal. Since then, the litigation has been winding through the system, with both sides filing mountains of briefs on history, data, and constitutional text. What's different now is that a Ninth Circuit panel has sided with the challengers under the Bruen framework, giving them a much stronger foothold if the case ever reaches the Supreme Court. And that's the next point. If the Ninth Circuit goes en banc and reverses the panel, the plaintiffs can petition the Supreme Court to take the case. The High Court doesn't take every petition. In fact, it takes very few. But given the prominence of the Bruen decision and the national implications of how lower courts apply it, there's at least a plausible path for review. That said, getting there would take time. You'd be looking at another year or more before any potential certiorari decision, and then briefing, argument, and decision on the merits. So, for those hoping that the panel's July ruling would mean immediate change, the reality is more like, hurry up and wait. We've got a petition pending, a response due at the end of the month, and then a vote by the judges. Until that plays out, the law is exactly as it's been for the past 6 years. That's frustrating for a lot of people, especially after reading a decision that says the system is unconstitutional. But it's part of how appellate courts work. From a broader perspective, Rhode v. Bonta is a test of whether the post-Bruen methodology will stick in the Ninth Circuit when the full court takes a Second Amendment case. Nguyen showed that a panel can and will strike down a state restriction when the historical record doesn't support it. Rhode shows that the same reasoning can apply to ammunition, not just firearms. The question now is whether 11 judges will agree or find a way to uphold the law despite that gap in tradition. If you're following along, the key dates to watch are August 29th for the plaintiff's response, and then whatever date the court announces its decision on the petition. After that, If en banc is granted, we'll get a new round of briefing, a new oral argument, and eventually a new decision. If it's denied, the panel's ruling becomes final, and the state would have to decide whether to ask the Supreme Court to step in. Either way, the stakes are high because the outcome will either reaffirm or narrow the scope of Bruen in this circuit. At this point, that's where things stand. Two big cases, Nguyen and Rhode, have delivered wins for challengers at the panel level, but only one of them is actually in effect. The other is on hold, waiting for a decision that could either lock in that win or erase it. I'll be watching the docket and the filings, and when there's movement, I'll be back to break it down for you. In the meantime, if you're in California and buying ammunition, nothing has changed yet, so plan accordingly. The legal process can be slow, but it's worth following every step when the outcome could redefine what the Second Amendment means in day-to-day life out here.